This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why a court refused to rewrite an insurance policy to provide coverage to an insured that he refused to purchase, and conclude that an insured of any insurance policy only gets the coverage he pays for. In Auto Owners Insurance Company versus Michael Cook, Michael Schuster, and Highland Auto Glass, the USDC for the Southern District of Illinois on March 9, 2023, dealt with auto owners' motion for summary judgment, seeking a declaration that its policy owed neither defense, indemnity, nor uninsured motorist coverage to the defendants. Schuster and Cook on one side and Devin Dahmer on the other were involved in an auto accident. Schuster, president and sole shareholder of Highland, was driving a van he and Highland jointly owned with Cook as his passenger. Both Schuster and Cook were injured in the accident. Cook sued Highland, Schuster, and Dahmer for negligence. Auto Owners seeks declarations regarding a tailored protection insurance policy. Auto Owners argued that the Auto Owners Garage policy, the tailored protection policy, did not cover vehicles owned by Highland or Schuster, like the vehicle involved in the accident. Schuster was driving a Ford Econoline van he and Highland owned jointly. Cook was his passenger. Dahmer pulled his van into the roundabout in front of the Highland van, nearly missing the van. Down the road, Dahmer pulled over and Schuster pulled the Highland van to the side of the road several car lengths in front of Dahmer's van. Schuster got out, and then Dahmer drove his van into the Highland van, injuring Schuster and Cook. Dahmer's insurance paid its limit to Schuster, and then Schuster made a claim for defense, indemnity, and UIM coverage under the Highland Garage policy. When obtaining insurance from auto owners, Highland paid premium for coverage under what was described as Division 2 of the policy, which limited the available coverage. The court, in reviewing the policy and the law, found that to determine if an underlying suit alleges a situation potentially within the insurance coverage, the court is required to compare the complaint to the relevant provision of the insurance policy. If any theory of recovery in the underlying complaint falls within the insurance coverage, the insurer will have a duty to defend. The garage policy is clear that the policy covers bodily injury arising out of an automobile, quote, not owned, hired, leased, rented, or registered by the insured or an officer if it is a corporation. Highland was the insured, and Schuster was an officer of Highland, and they both owned the Econoline van. So there was no coverage under that section for bodily injuries arising from the Econoline van, including from the collision between Dahmer and the van. The only identified garage policy provision that would potentially cover bodily injuries arising out of an automobile owned by the insured was Division 1 coverage, which Highland did not purchase. Since there is no coverage of the Econoline van under Section 2, there is also no underinsured motorist coverage arising from an accident with that van. Schuster agreed, but claimed that the exclusion, at least to the extent it precludes UIM coverage, violates public policy. Now, the insured, of course, bears the heavy burden of showing an insurance provision violates public policy. Schuster, however, pointed to nothing in the garage policy that violates Illinois public policy. Rather, he asked the court to award him the coverage he personally declined to purchase. It does not violate public policy to exclude coverage and an insured expressly declined to purchase when it was available. The court also noted that Schuster was not being left without a remedy for injuries caused by an underinsured motorist. Schuster maintained a separate personal automobile policy from Owners Insurance Company, an affiliate of Auto Owners, as required by the financial responsibility law, and owners paid the UIM coverage under that policy. The court, therefore, obviously granted Auto Owners' motion for summary judgment and directed the clerk of the court to enter a judgment accordingly, including declarations that Auto Owners owed no duty to defend or indemnify Highland Auto Glass, Inc., and Michael Schuster in connection with the lawsuit Cook versus Highland in the Circuit Court for the 3rd Judicial District, Madison County, Illinois, and plaintiff Auto Owners Insurance Company owed no underinsured motorist coverage to Michael Schuster under the Auto Owners policy. In my opinion, a person seeking insurance is always faced with the obligation to determine what coverage to buy before an accident occurs where the coverage will be needed. The insureds in this case chose a limited coverage, declined to buy a more extensive coverage, and after an accident tried to get the court to cure their error with an argument that the policy violated public policy and give them the coverage they personally refused to buy. Courts are required to interpret insurance contracts. They are not required to, nor will they ever, rewrite a policy. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and will be given notice of every blog posting, usually 5 to 6 a week. And you can also subscribe to the videos on rumble.com or youtube.com. And if you watch these videos, please click on the like button or the rumble button as you do if you find them useful. And if the videos of the blog posting are useful to you and to your friends and colleagues, please tell them about it so that they too can subscribe to the YouTube, the Rumble, and to the blog. And you might also find it worthwhile to subscribe for the small fee to my Substack publications or my locals community. Thank you for your attention.